Okay, New York v. Jonathan Majors has ended and a verdict has been reached. And I want to just give a global recap of the remainder of this case so that we can get to talking about the verdict, because what happened here is very interesting to me. So first, we'll go over the final day of testimony, which was the defense's entire case in chief. Then we'll go over the closing arguments, and then we'll go over the verdict. And by the way, if you are just now jumping into this case, the state of New York alleged that on the night of March 24th / morning of March 25th, 2023, the actor Jonathan Majors physically assaulted Grace Jabbari, his then girlfriend. I have a whole playlist of videos linked in the description below, so check it out if you want to binge all of my recaps together. But basically, I'll tell you up front that I said in the last recap that, in my opinion, based on the information I had when the prosecution rested, I thought this case really should end with an acquittal. And now he's been found guilty of 2 of the charges and not guilty of the other 2. We'll get into how the jury decided on each count and how I think each result happened. But first, let's get through the final bit of testimony in this trial, which was day 8 of the trial. Like I said, on day 8, the defense put on their entire case in chief, and that consisted of 3 witnesses. There was a police officer, a medical expert, and Jonathan Majors' own agent. Jonathan Majors did not testify, as is his right under the Fifth Amendment. The decision to testify or not testify is always a tricky one, and it's typically a strategic one as well. In some cases, where the defense is putting up an affirmative defense, like self-defense, for example, it very often is the case that the defendant pretty much has to testify. That's because affirmative defenses shift the burden as to that particular question, whether the defense is legally justified in harming someone else. But otherwise, in most criminal cases, I would say that generally speaking, the safest route is usually to invoke the Fifth Amendment and to waive your right to testify. And that's because there are so many ways for the testimony to get bogged down in side matters, and the defendant may, under pressure, make an admission or say something else that makes the case basically go sideways. In this case, I'm honestly 50-50 on whether or not it was the right call for him not to testify here. Obviously, we can think of ways in which it could have benefited his case for him to testify. The prosecution alleges that there was an assault that happened inside the SUV where there were 3 people, Jabbari, Majors, and the driver. The other 2 testified, and to be honest, the driver's testimony was mildly helpful, but not entirely. Remember, he testified to hearing things but not seeing things. He was focused on driving, and so he didn't actually look back to see who was hitting whom. He said he was focused on the road, and so he had an impression that Jabbari was the aggressor, but that's as far as his testimony could go. So he's not exactly an eyewitness. So in theory, at least, Major's testimony could have given his side to combat Jabbari's testimony about what happened in the car. He could have explained, for example, look, she grabbed my phone from me, and in the process, she ripped off the buttons in my jacket, and she kept coming at me, and all I wanted was my phone back, and she indicated that she was not going to give it back to me. Even after all of this was said and done, she kept my phone, and to this very day, I don't have it because I never got that phone back from her. And he could have said, I never intended to hurt her. I never used any force beyond what was necessary to get the phone back from her. Then she kept coming at me, and I just wanted to get out of the car before it got worse. But the potential problem with him testifying is it could have ended up sounding like, hey, she took my phone and so I retaliated because I'm the big guy and she should know better. There's a fine line between the two where one explanation means a legal justification of some physical force, and the other means basically an excuse that an abuser might make for physically abusing their partner. And so I would understand if they had some trepidation around the possibility of him testifying about this event because of that fine line. And at the same time, there have been some pieces of information that came out at trial that some people have found to be distasteful. This includes the recording where he references Michelle Obama and Coretta Scott King, of course. I know that Major's team did not want this to come out at trial, and they did not want it to go public. But honestly, though, I think that if they had decided that he was testifying, they could have leaned into it and explained it away head on. Sometimes doing that takes the sting out of a recording like that sounds very damaging, whereas trying to hide from it sounds like you are basically saying, we know that this is wrong, we know that this is bad, and we don't want anyone to see it. We want to hide it from everyone. Rather, if he had testified, he could have explained that the conversation was a result of the demands on him for his work and the more specific circumstances around that conversation that maybe we don't know about because it was basically taken out of context. If he had testified, he could have explained, for example, how this was him expressing to his partner that he expects his partner to not only understand the sacrifices that he's had to make in order to become a prominent figure in Hollywood, but also that he needs someone that is going to get on board with what is required of his partner if they are going to be a long-term power couple and if they are going to exist in that realm. Instead, without that explanation, the defense was basically at the mercy of everyone listening, whether that's in the court of law or in the court of public opinion, to come to their own conclusions with very, very limited information. And based on the things that did come out and the way in which they came out, it wouldn't surprise me if Majors actually has a lot of anxieties and so has tried to perfect in light of those anxieties. And by perfecting, I mean not allowing the world to see your vulnerabilities. There was evidence that came out at trial of some mental health issues that he's been dealing with, like when he said in text messages that he's considered unaliving himself. And so he might not actually be in a place where he's able to really adequately recognize those things and face them head on. And if that's the case, his cross-examination would have a fairly decent chance of maybe not going so well. So, okay, that's the bit about Jonathan Majors not testifying. Let's turn to the 3 defense witnesses who did testify. The first was NYPD Detective Ronnie Mejia. I'll be honest with you, I think that his testimony was somewhat pointless. It really didn't move the needle one way or another. And I think him going first was a bit of a missed opportunity for the defense. I think that the intent by the defense was for his testimony to show that Grace Jabbari was the aggressor and that Jonathan Majors later even filed a complaint against her for physically assaulting him on the night in question. But there was only so much that he was allowed to testify to on that subject. And so that's about all that I was able to get from his time on the stand. There's been plenty of evidence that has come out at trial elsewhere for the defense to make the argument at closing that they want, that she was the aggressor in the alleged altercation. They didn't really need this testimony to be able to make that argument at closing, in my personal opinion. And whether that argument is convincing to the jury is not likely to be impacted by this witness's testimony, which makes it basically a waste of time, in my opinion. Now, the second witness was Dr. Tammy Weiner. She is an ER physician at Danbury Hospital in Connecticut, and she testified as an expert witness on emergency medical matters. Now, this is a good expert to bring in for the defense. This is because the defense's case needs to attack the idea that Majors caused Jabbari's injuries, and it needs to attack the idea that he had the requisite mental state for the assault charges. So this testimony here is going after that first part. And what Dr. Weiner testified was that she looked at photos and x-rays of the injuries in Jabbari's medical file and that she came to some expert opinions. Now, as I noted before, expert witnesses can be totally disregarded by the jury if they think that their opinions are not particularly helpful from an objective standpoint. And so given that this is an expert testifying for the defense, we can totally expect her to say that she thinks that the injuries that resulted could not have been caused in the way that Jabbari said that they were caused. And that's exactly what she said. First, as to the ear lacerations, she said that she would have expected to see more bleeding around the ear. She also said that the way that the cut was made was not consistent with the claim that it was a result from a sharp blow to the head. And that's because she said that she would expect to see more bruising and swelling in that area if that were the case. On the issue of the fracture, she also expressed doubt that that had been caused by a twisting motion. She said that fracture spirals around the bones that come from twisting injuries typically resemble stripes on a candy cane. And although I haven't been able to find out what exactly the fracture in this case looked like, the implication here seems to be that Jabbari did not suffer from a spiral fracture. Now, she also talked about Jabbari's ability to use her hand after the alleged incident. This obviously is pointed right at all of the surveillance footage that shows her using her right hand in the hours after the alleged incident. And what Dr. Weiner said is that she would expect Jabbari not to use her right hand due to the pain of the injury. Specifically, she said even if it was your dominant hand, you would avoid using it for actions you'd normally use your dominant hand for. And this, of course, makes sense, but we also do need to consider that there is some variability between different people and their pain tolerances and things like that. This is not me coming to the defense of Jabbari here. This is just stating something that I know to be true. I couldn't find if she was cross-examined, but if she was, I would imagine that they would have pointed this out on cross-examination. Now, the last thing that I do want to say about Dr. Weiner's testimony is that the defense really did try to test the limits of how far she could testify. And this was shown through a bunch of sustained objections. Here is a list of questions that she could not answer due to the various objections. Is the break in Ms. Jabbari's finger consistent with your finger being twisted? In your medical opinion, how did Ms. Jabbari sustain this fracture to her finger? How likely is it that the fracture to her finger was sustained by twisting? Can people consume enough alcohol to not feel pain at all? What would a human hand have to do to cause the injury that was sustained to the ear? So she was not able to testify as far as the defense would have liked. And I noted before that the state did not introduce any medical expert witnesses to talk about these various issues and how it could be the case, for example, that Jabbari was able to use her right hand all night in the presence of a fracture on her finger. Now, it could be that they felt that this was sufficiently covered by Jabbari's treating physician. And maybe he testified to these matters being discussed by the defense expert, and we just didn't see it because there are no cameras in the courtroom. Either way, this witness, in my opinion, was helpful to the defense's case because her testimony went into the "he couldn't have caused these injuries" box. Now, how helpful was it? Well, in the end, it didn't convince the jury, so it obviously did fall short, at least in some way. Anyway, the third witness was Elan Ruspoli, Major's agent, and I apologize if I am mispronouncing that name. His testimony was pretty limited as well, and I think the purpose of his testimony was to further illustrate the fear about Jabbari's state that the defense wants the jury to believe Majors was feeling that morning. Either that or the fear he felt in having to call the police to help her in whatever state she was in. If the jury can believe that Majors was genuinely afraid either for Jabbari's welfare or for his own sake in calling 911, maybe that means he legitimately thought that she was trying to unalive herself and that therefore his mental state didn't reflect someone who had abused his intimate partner the night before. Anyway, Ruspoli testified that on the morning of March 25th, around 7:45 a.m. Los Angeles time, Majors called Ruspoli. He said that he was on the phone with Majors when Majors was knocking on the door to his apartment bedroom. And actually, he described it as a very loud banging noise that got louder with each bang. He said Majors sounded beyond concerned, distraught, and worried. And he said, "I've never heard him like the way he was on that call." And when the defense had him listen to a playback of the 911 call that Majors had made, Ruspoli testified that Majors' tone on that call mirrored his tone when he was talking to Ruspoli. So, that's it for the defense witnesses. I don't know if there was an attempt by the defense to bring in an expert qualified to talk about the effects of alcohol on the brain and perception and memory and pain. But if not, I would kind of find that surprising given how much attention was put on Jabbari's drinking that night. And keep in mind, technically the defense doesn't need to call any witnesses at all since they don't have any burden of proof in this case. That said, if you do want to put on an adequate case, you generally do want to put on enough witnesses to tell the story through your party's side. It's basically considered best practices. Part of reframing the narrative is done through cross-examination of the prosecution's witnesses, of course, but part of that is also getting your own people in there to reframe the story for the jury. And when I talked about the pendulum swinging before, I said that usually at the end of the state's case in chief, very often it should feel like in this case, the prosecution has a conviction in the bag. It should feel like the jury should decide with the prosecution. And then as the defense puts on their witnesses, the pendulum very often swings at least a little bit in the opposite direction, depending, of course, on the actual evidence that comes out. In this case, at the close of the state's case in chief, I personally was feeling like the pendulum still was somewhat in favor of the defense because there were questions that I thought were still unanswered. And this, of course, is coming from the perspective that the defendant is innocent until proven guilty. I will say, though, that the defense witnesses, at least to me anyway, did not move the pendulum any further towards the defense. I personally still think that there is reasonable doubt in this case, but I can't help but wonder what other witnesses could have been more effective here. Okay, so now let's talk about the closing arguments. Remember how I said at the beginning of this series that when we are talking about closing arguments, those are essentially bookends to the trial along with the opening statements at the very beginning. Opening statements are generally where the two sides lay out a theme for how to organize all of the information as it comes out at trial. And then closing arguments are where you take all of those pieces of evidence that did in fact come out in front of the jury and you arrange them into a picture that tells your side. Closing arguments is where the attorneys can and should argue from the evidence that was admitted to basically make a final case to the jury. And in my opinion, the most effective closing arguments are the ones that essentially find the jurors that are basically on their side and arm them with information and with arguments. This is because it's often the case that there are jurors who support one side or another going into deliberations. And in deliberations, the jurors discuss the evidence and they make the case to each other why they think one way or another. So closing arguments really are deputizing the jurors that are most favorable to your case so that they can go into those deliberations armed with all the best information and the arguments for your side. And that's why a good closing argument will often address different questions that might be asked by the jury on various points that need to be figured out. For the state, this was talking about each of the elements of the charges and talking about why the evidence supports conviction on each one. For the defense, it's doing the same thing, but talking about where there are gaps in the state's case and why those gaps represent reasonable doubt, which would prevent a conviction. Okay, so what happened in this case? Let's first talk about the charges really quickly. There were 4 of them. 2 were for assault and 2 were for harassment. The first charge was third-degree intentional assault. Here, the state needed to show that Majors physically injured Jabbari and that he specifically intended to do so. The second charge was third-degree reckless assault. For this one, the state needed to show that Majors physically injured Jabbari and that he maybe didn't intend to hurt her, but that he harmed her through his recklessness. Now, recklessness in this context means that he knew of a risk that he was creating by doing something or failing to do something, and that he consciously disregarded that strong likelihood that someone would get hurt. So it's not the same thing as negligence, where you simply weren't being careful and you should have known better. It requires really getting into the defendant's brain and figuring out what he knew, what he didn't know, and what decisions that he made based on what he did and didn't know. Anyway, the third charge was second-degree aggravated harassment. This is where the defendant intentionally harasses a person. They do something to annoy that person and they intend to annoy that person. And where the defendant also ends up intentionally harming that person through that harassment. So again, there's intent on both of those pieces. And finally, there's second-degree harassment. This is where the defendant annoyed the victim and did so intentionally. But unlike aggravated harassment, there's no element of any kind of a physical injury. Now, importantly, the first 3 charges are misdemeanors, so they're punishable by up to a year in prison. The fourth one, however, while a violation under the New York Penal Code, is not a crime. It's essentially the same thing as getting a speeding ticket. Now, if you go around harassing people on the street, you can get cited for it, but on its own, that does not make someone a criminal. Okay, so with all of that in mind, what did the 2 sides go over in their closing arguments? Again, as always, an asterisk because I couldn't watch it in person. So there's always a possibility that there could be elements that were not entered into my summary because they weren't reported, or at least because I didn't see them reported. One thing that was interesting off the bat was that the defense went first in their closing arguments. Normally, because the state has the burden of proof, the prosecution goes first and the defense goes second. And then if the state has reserved any time for it, they can finish their closing with a rebuttal after the defense gives their closing. But here it looks like the prosecution reserved their entire closing for rebuttal. So the defense went first. What did they say in their closing argument? To sum it up, defense attorney Priya Chaudhry spent her time basically talking about Grace Jabbari being a lying liar who lies. She started out by saying, "Why are you here? You're probably wondering why you just spent the last 2 weeks of your life to see what is obvious to anyone interested in facts and evidence. Grace Jabbari was not hurt when she got out of the car on Center and Canal." Then she said, "Jonathan Majors is innocent and Grace Jabbari is a liar. There's no mystery about what happened in the car. The driver told us." And let me just say, this is not necessarily a strategy that I would want to use. In my personal opinion, this case is anything but clear. There's kind of a lot of mystery as to what happened inside the car, and that actually is really helpful to the defense. If this were my closing, I would probably want to start off by saying something like, reasonable doubt is the currency in this trial. How much doubt do you have about all of these different things that the state needs to prove? Once you have reasonable doubt as to any single element of a charge, you have to acquit on that charge. So then I'd go to each point and I'd say, the supposed fight in the car. She says Majors was the aggressor and that he hurt her, but the driver said XYZ about her being the aggressor. Doubt. She says that Majors caused the laceration behind her ear, but the driver said that there was no blood found in the car. Doubt. She says she knows that Majors caused this. But she also woke up the next morning and first thing asked the police, "Why does my ear hurt?" That's doubt. I might even start making some kind of visual tally, like on a whiteboard or something along those lines. Now, Chaudhry did point to some of these things, like the fact that there was no blood found in the car. But my point here is to say that I think she took a different kind of tone and strategy with the information she packaged than what I personally would take. To say this case is clear, in my opinion, this case in particular, I don't think it is a clear case. And I think that lack of clarity actually should have been highlighted by the defense to make the case that the state did not meet their burden. Anyway, another thing that she focused on was the fact that Jabbari went out that night. She called it revenge partying. And there is a lot there to support the argument that the defense can make that her finger was not injured until after the incident inside the car. But Chloe Zoller did testify that Jabbari complained about her finger hurting when they entered the nightclub and that she offered Jabbari ice from the champagne bucket in order to ease that pain. This could be disregarded by some, but this is a bad fact for Majors and something that should have been addressed in the closing argument. And this is also where we get to the subject of alternative arguments in closing arguments. When the two sides are making their case to the jury, there are ways in which they can argue alternatives. Generally speaking, you don't want to be arguing alternative facts. You want to present a cohesive universe of facts so that you're telling a single narrative to the jury. If you try to prevent variant timelines that are different versions that kind of support your side, the jury is likely to call BS on you. On the other hand, alternative arguments are totally game, because these are arguments from the facts that have been presented. For example, you could say, if you think that X happened, we still win because it actually means Y. Here, an alternative argument could be, look, what matters here is what happened inside that car. Majors didn't cause the injuries to Jabbari. She did not have those injuries when she left the car. You can see that because of X, Y, and Z. But even if you do think that she caused them, you still have to decide on his mental state. Here's why you can't find any evidence of his intent to harm her. Here's why you can't find any evidence of him being reckless in doing the things that he did. And because of that, you can't find him guilty of either of the physical assault charges. And the same kind of argument could be made for the harassment charges as well. Similarly, I was surprised that there was nothing said about the fact that she had taken his phone from him and that he was trying to get his phone back. There was nothing in the closing arguments, at least from what I saw reported, talking about how under New York law, a person is justified in using physical force to stop a larceny. And the thing about recklessness is something can't be a reckless act if that person is legally justified in doing it. For example, if someone comes up to you on the street and tries to take your wallet, you're generally going to be justified in breaking their finger to stop them from doing that. They can't turn around and sue you for the harm that they've experienced as a result. Obviously, there's a way of going outside the scope of what is reasonable considering the circumstances, but we don't need to go down that road. We're just using this as a hypothetical. And so now, obviously, we're not talking about a stranger taking the phone. We are talking about someone who lives with him. So would the jury have been convinced by that argument? I don't know, but it sure as hell is worth at least making the argument to the jury. Instead, Chaudhry pointed to the surveillance footage of Majors and Jabbari getting out of the car, and she characterized it as him being very helpful to her for her safety. Specifically, she said, he puts her back in the car because they're in the middle of traffic. She keeps grabbing him. He tells her to leave him alone. He helps her out of the car. He walks her safely to the sidewalk. Personally, that was not the impression that I had of what was happening while watching the surveillance. To me, it looked like he thought that he had left her behind in the car and that he didn't realize that she was behind him until he reached the sidewalk and she reached out for his left hand with her right hand. Everything about this characterization by the defense in closing was confusing to me because it didn't seem to fit with what they were trying to argue. So if that's actually what happened, according to maybe what Majors told Chaudhry behind the scenes, I don't know why the defense attorney wanted to highlight that part. Anyway, she also did hint at racial bias when she referred to Pretty Little White Lies by Jabbari. It was very poetic, I suppose, to rhyme white lies and big lies and prosecutors' white lies and all her pretty little lies. But it makes me feel like the focus of the closing argument was more on the artistic presentation rather than on the elements that needed to be addressed for each charge. And one possibility is it could have set off a BS meter for the jury. Anyway, she basically ended up with questioning why Majors, who had a fear of the police, would call the police if he had done these things to her. She said, if you believe Grace, then despite Jonathan Majors telling her how dangerous it is for a Black man to call the police in America, despite that, He beat her badly in a car that was both in his own name, and then he called 911 himself. She also said, if you believe Grace, then Jonathan caused these injuries and then told the 911 operator about her injuries and then told the cops who showed up at his apartment that they had an argument the night before. And apparently Majors started crying shortly after Chaudhry said his fear of what happens when a black man in America calls 911 came true, and now we're here. Look, I can understand why the defense would want to talk about these matters. To me, it does seem like Majors does have a sincere and authentic fear of these kinds of situations. There's been enough evidence that came out at trial to suggest that. The problem with this is, I think, in the delivery. The way this was delivered is the defense is arguing from essentially a statistical likelihood about what Majors could have done, rather than the actual concrete evidence that came out at trial. And that's just not a convincing way to argue a case to a group of objective people. All of this definitely does bookend the theme that Chaudhry had in her opening statements. However, I think that she really hamstrung any pro-defense jurors by not talking much about anything else other than the racial bias argument and the Grace is a liar argument. Okay, so that's the defense's closing. What about the prosecution's rebuttal closing? ADA Kelly Galloway got up and essentially told the jury, this case boils down to 4 words: control, domination, manipulation, and abuse. She highlighted that the trial was only about what happened at the car. And on that note, she said, you didn't see any evidence that the defendant was attacked whatsoever. And the thing is, on that point, I think she's right. There's a suggestion that Jabbari did, from the driver saying that he felt like she was the aggressor to Majors then running away from her for 5 to 6 blocks. But that's another issue with the defense's closing, is that they went so hard on Grace Jabbari is a liar in every way that they opened themselves up to being checked by either missing pieces of evidence to support that claim or places where Jabbari's testimony was in fact corroborated. And there were some points of corroboration, as I noted earlier with Chloe Zoller's testimony. And in the prosecution's closing, Galloway further pointed out that Jabbari was not the one to call 911, and she said that she didn't want to report it to the police. She also pointed out how at no point did Jabbari tell anyone about the prior September 2022 incident. She said Jabbari kept that private because she didn't want to ruin the relationship. She didn't want to tell anyone what was going on. And so she said, how could this be a plot to seek revenge on Majors if she didn't even call 911 in the first place? Now, of course, I can see people in the comments right now saying she intentionally made it look like she was trying to unalive herself in order to prompt Majors into action. Maybe, but I'm just pointing out that that is the argument that the state is making here, and it's something that the jury may have found convincing. And again, by not presenting these other alternative arguments, the defense really hamstrung their whole case here. Now, this, of course, is where my job is arguably easiest, because there are so many strategies that a trial attorney can use, and at the end of the day, the quote-unquote right strategy is generally the one that wins. So it is very easy for me to Monday morning quarterback here and point out all of the faults by the defense team. But this channel is all about breaking down the law and making the judicial system more accessible and understandable. And sometimes that means also explaining where I disagree with the attorneys and even judges involved in these cases. Okay, so here are my thoughts on the verdict. Ultimately, the jury acquitted on 2 charges and convicted on the other 2. The 2 where they acquitted him were the 3rd-degree intentional assault charge and the 2nd-degree aggravated harassment charge. Both of those are misdemeanor charges. Then they found him guilty of 3rd-degree reckless assault and 2nd-degree harassment. So in the end, he's been convicted of 1 misdemeanor and the 1 non-criminal violation. A lot of people are scratching their heads about how they could come down to this split. And what it tells me is that they decided that Majors did not intend to cause harm to Jabbari. However, they did find that he was reckless in causing harm to Jabbari. They basically said that he knew that there was some risk of harm that he was creating at some point, and that he proceeded to act without justification, consciously disregarding that risk. Personally, based on the evidence that I have seen that has come out at this trial, I don't think there's enough evidence to show that all of that entered his brain on that night. Now, I could see a jury looking at everything that was presented and find, say, negligence. They could say he should have known that what he did would cause her harm. But that's not the same thing as knowing that what you're doing is likely to cause someone harm and consciously saying, you know what? Screw it. Let's go for it. But I think that it was up to the defense attorney to hit that point in closing arguments to make sure of 3 things. First, that the jury understood what recklessness actually is. Second, that there is a big hole where the state should have presented evidence as to his mental state and how that means that there's all kinds of reasonable doubt on that point. And third, whatever evidence there is showing that Majors maybe couldn't have had that mental state. They could have, for example, pointed to the fact that he knew that she was a dancer, he knew that she was incredibly fit, and that he knew that she was using a certain amount of force on him. And so he needed to use a certain amount in order to restrain her from attacking him, for example. From what it looks like, the defense did not do any of that. The defense attorney here was a little too focused, I think, on the argument that Jabbari was a liar and that there was racial bias. And I think that this was an unforced error on the part of the defense team. Like I said, to me, this was a gray case through and through. Do I think that Majors assaulted Jabbari? Honestly, I don't know. It's possible. It definitely is possible. But there are too many unknowns, in my opinion, to convict on that question. And maybe part of it is because of the uncertainty of getting information from this trial secondhand. But based on what I do know to have been presented in this case, I can't say that I would be ready to say that Majors is innocent. But I also don't think that I would be able to convict him either. And in the end, muddy middle goes to the defendant. But those are my thoughts. What do you think? Let me know all your thoughts in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more trial coverage like this, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you in the next one.